Hello and welcome back to another episode of Courts This Week, presented by LiveLaw. I am your host Anna Oman and I'll take you through the most significant courtroom developments from across the nation. From the Supreme Court to local courts, I've got you covered with crisp and clear summaries. But for a deeper understanding, I will always encourage you to check out the news articles available on our website www.livelawmedia.in. In this episode, we are going to talk about the electoral bonds case, pleas seeking a stay on the freshly notified Citizenship Amendment rules, the challenge against the Election Commissioners Act that drops the Chief Justice of India from the selection panel, the farmers' protest and much more. So let's dive into the headlines. In the latest update on the electoral bonds case this week, the Supreme Court rejected the State Bank of India's plea for more time to reveal details of electoral bonds. It's worth noting that the electoral bond scheme was previously declared unconstitutional by the Supreme Court on February 15th. This week, the court stressed that the bank already possesses the necessary information and instructed it to disclose these details by March 12, 2024. SBI had requested an extension citing difficulties in decoding and organizing the data. However, the court clarified that its order simply entails straightforward disclosure, not a complex matching process. The required information includes the purchase date, buyer, and bond denomination since April 12, 2019. Moreover, the court warned SBI of potential contempt proceedings if it fails to meet the deadlines. Additionally, the Election Commission of India was instructed to compile and publish this information by March 15th. Following this directive, the SBI on March 12th furnished the electoral bond details to the Election Commission of India in compliance with the court's order. The ECI promptly announced this development via its spokesperson on X, formerly Twitter. Additionally, on March 13th, the chairman of the State Bank of India, Dinesh Kumar Khara, filed a compliance affidavit in the Supreme Court affirming the submission of electoral bond details to the ECI. The affidavit outlined that the bank provided the information in two separate packets, one containing details of bond purchasers and the other containing information on political parties redeeming these bonds. Furthermore, the SBI clarified that between April 1st, 2019 and February 15th, 2024, a total of 22,217 bonds were purchased, while 22,030 bonds were redeemed during this period. In a subsequent move, on March 14, the Election Commission of India uploaded the electoral bonds data supplied by the State Bank of India on its official website, adhering to the court's directives for transparency. In another news, the Supreme Court addressed the ongoing matter concerning electoral bonds again later this week. The bench comprising Chief Justice D.Y. Chandrachud and Justices Sanjeev Khanna, B.R. Gavai, J.B. Pardiwala and Manoj Mishra was reconvened to hear an application filed by the Election Commission of India. The Commission sought the return of sealed envelopes containing electoral bond details furnished previously to the Apex Court, stating that it did not retain copies to maintain confidentiality. On March 11th, while dismissing SBI's application for an extension of time granted to furnish electoral bond details, the five-judge bench had also asked the Election Commission of India to publish the details of the information supplied to the court in pursuance of its interim order on the Commission's website. By this interim order issued in November last year, ECI was asked to furnish in a sealed cover details of the funds received by all political parties through electoral bonds till September 30th. This week, the bench disposed of ECI's application for a return of the sealed cover details with an instruction to the Registrar General to ensure the scanning and digitization of this data by 5 p.m. on Saturday, after which the original copy would be returned to the Election Commission. The digitized files will also be made available to them. Notably, during this hearing, the Supreme Court said that the SBI must disclose the alphanumeric number corresponding to each electoral bond in addition to the information it has already disclosed relating to the purchase and redemption details. On Solicitor General Tushar Mehta's insistence, the court issued notice to the State Bank of India since it was unrepresented on this particular occasion and posted the matter for further hearing this Monday. This week, the Supreme Court agreed to hear petitions seeking to halt the implementation of the recently issued Citizenship Amendment rules on March 19th. The petitioners assert that the Citizenship Amendment Act (CAA) is unconstitutional because it ties citizenship to religion. They argue that this approach could lead to irreversible and unjust consequences. Enacted in 2019, the CAA aims to streamline the process of granting Indian citizenship to non-Muslim migrants from neighboring nations. However, its religious criteria have sparked widespread protests and legal disputes. While the government contends that the law doesn't affect the citizenship of any Indian, critics argue that it contradicts India's secular principles. The government notifying the rules for enforcing the CAA earlier this week led to several political parties and organizations approaching the Supreme Court with an urgent request to stay the rules. Among the petitioners are the Indian Union Muslim League, AIMIM leader Asaduddin Owaisi, All Assam Students Union and others. They have questioned the compatibility of these rules with constitutional provisions and agreements such as the Assam Accord. This is a developing story and we will be back with more information, so stay tuned. This week, the Supreme Court postponed the hearing on petitions challenging the recent law that removes the Chief Justice of India from the panel appointing election commissioners. The court rescheduled the proceedings for March 21st, noting that certain interlocutory applications praying for a stay were absent from the record. Justices Sanjeev Khanna, Dipankar Datta and Augustine George Massey presided over writ petitions filed by Congress leader Jaya Thakur, the Association for Democratic Reforms and others. They have sought an urgent hearing in view of the upcoming Lok Sabha elections and the resignation of Arun Goyal, a former election commissioner. These petitions challenge the constitutionality of various provisions within the Chief Election Commissioner and Other Election Commissioners Act of 2023. One petitioner referenced the Anup Paranwal ruling handed down by a constitution bench last year, arguing that it could not be reversed by the Parliament. This ruling mandated that election commissioners be appointed by the President of India based on the advice of a committee comprising the Prime Minister, the Leader of the Opposition in the Lok Sabha and the Chief Justice of India. Despite the petitioner's plea, the court hesitated to suspend the Act's operation, citing past precedents. The petitioners in turn highlighted instances where laws were stayed. It was also pointed out that the selection committee meeting for new election commissioners was moved up, leading to the appointment of 2 new election commissioners in terms of the new law. At the heart of the petition lies the argument that the 2023 Act would allow the executive interference in the selection process of election commissioners by replacing the Chief Justice of India with a Union Cabinet Minister in the selection committee. This week, the Supreme Court rejected the curative petitions filed by the Aam Aadmi Party leader and former Delhi Deputy Chief Minister Manish Sisodia, who sought bail in the Delhi liquor policy scam case. The bench, consisting of Chief Justice of India D.Y. Chandrachud, Justices Sanjeev Khanna, B.R. Gavai and S.V.N. Bhatti, dismissed the petition, stating that they did not present a compelling case. Sisodia faces charges from both the Central Bureau of Investigation and the Directorate of Enforcement. This decision follows previous rejections of Sisodia's bail pleas by the Supreme Court and subordinate courts. However, while dismissing his bail plea, a bench led by Justice Sanjeev Khanna had clarified in October last year that he could reapply for bail if the trial fails to progress. Sisodia has been in custody for over a year, having been arrested in February 2023 over the alleged Delhi liquor policy scam. In another important development, the Supreme Court dismissed the West Bengal government's appeal against the Calcutta High Court's decision to transfer the investigation of an attack on Enforcement Directorate official in Sandeshkhali to the Central Bureau of Investigation. While rejecting the plea, the court also acceded to the petitioner state's request to remove critical remarks made by the High Court concerning the conduct of the state government and the police. The High Court had expressed concerns regarding the state police's handling of the case and alleged political influence. The accused Shahjahan Sheikh, who has political connections, evaded arrest for over 50 days before being apprehended. In its order, the High Court Division Bench led by Chief Justice T.S. Sivagnanam had noted, and I quote, "The state police is totally biased and every attempt is being made to delay the investigation to protect the accused who has been absconding for more than 50 days." This week, the Supreme Court chose not to stay the Bombay High Court's decision acquitting Professor G.N. Saibaba and 5 others in a case concerning alleged Maoist affiliations under the Unlawful Activities Prevention Act 1967. The bench led by Justice B.R. Gavai remarked that the High Court's judgment was prima facie well-reasoned and pointed out that the accused had been acquitted twice by separate benches. The case originated from the arrest of G.N. Saibaba and his co-accused in 2014 on charges of having links with proscribed Maoist organizations and waging war against India, followed by their conviction in 2017. One of Saibaba's co-accused died during the pendency of their appeal against their conviction. Previously, the Bombay High Court had acquitted them in 2022 on procedural grounds. However, the Supreme Court initially stayed and later overturned this acquittal, ordering a fresh review by a different bench after considering the matter on all aspects, including the merits. Once again, a different division bench of the Bombay High Court has acquitted G.N. Saibaba and other accused in the Maoist links case, finding that there was no evidence to implicate them. The state of Maharashtra has approached the apex court in appeal against this ruling. In another important case, the Haryana government lodged a special leave petition in the Supreme Court of India challenging the Punjab and Haryana High Court's decision to initiate a judicial inquiry into the death of a 21-year-old farmer amid protests. The High Court had constituted a committee to probe the incident due to concerns about impartiality if handled solely by either state. It also questioned the police's use of force and criticized the delays in filing the first information report. Additionally, the court questioned the Haryana government regarding the ammunition used by the police on protesters, demanding detailed information. After reviewing the state's affidavits, the High Court remarked that the death appeared to result from excessive police force. It also reprimanded the Punjab police for the delay in lodging the FIR, as the incident occurred on February 21st, yet the FIR was filed on February 28th. The farmer's father, in his petition to the Punjab and Haryana High Court, alleged the use of undue force and urged transparency regarding the weaponry employed. The petition also censured Punjab authorities for not raising objections despite the incidents occurring within their jurisdiction. In a development relating to the rift in the Nationalist Congress Party, the Supreme Court made some critical observations this week while hearing Sharad Pawar's plea challenging the Election Commission's recognition of Ajit Pawar's faction as the official NCP. The court instructed Ajit Pawar's group not to utilize Sharad Pawar's name or likeness in their campaign materials, asking it to stick to its distinct identity following the separation of the two factions. Senior advocate Maninder Singh, representing Ajit Pawar's side, agreed to submit an undertaking to this effect before the next date of hearing as per the court's instruction. But that's not all. During the hearing, the bench led by Justice Suryakant also suggested that the Ajit Pawar faction to consider using a symbol other than the clock, given the ongoing legal dispute. This observation came after senior advocate Abhishek Manu Singhvi pointed out that the clock was linked with the identity of Sharad Pawar in the minds of voters and could create confusion. The case has been posted for further hearing on 19th March. Let's now turn to the case of the stand-up comedian Kunal Kamra. This week, the Bombay High Court, in a majority decision, declined to halt the union government from establishing its fact-check unit in accordance with the 2023 IT Rules Amendment case. This rule grants authority to the government to identify online content pertaining to its affairs as fake, false, or misleading. Social media platforms are then obliged to remove such content or face legal repercussions. Justice A.S. Chandorkar, aligning with the union, asserted that no imminent harm would arise from the unit's implementation. This ruling following a split verdict in January 2024, where Justice Gautam Patel advocated for striking down the rule, expressing concerns about censorship and violation of free speech. Conversely, Justice Neela Gokhale upheld the rule, contending that it targets only fake or misleading content and not genuine opinions. Gokhale had further highlighted that the rule does not mandate the immediate removal of flagged content but permits intermediaries to issue disclaimers. This week, a public interest litigation has been filed in the Punjab and Haryana High Court challenging the appointment of Nayaab Singh Saini as the new Chief Minister of Haryana. Saini is currently an MP from Kurukshetra Lok Sabha seat. He has been sworn in as the new Chief Minister of Haryana since the former Chief Minister Manohar Lal Khattar and his cabinet had to resign. The PIL says that he is currently an MP and at the same time the Chief Minister, and holding both positions simultaneously is against the Constitution and the Representation of Peoples Act 1951. The petition states that Saini's appointment crosses the limit of 90 MLAs in the Assembly and it is unlawful and deceitful. The PIL also challenges the appointment of 5 cabinet ministers and demands a suspension of their salaries and perks. Now there is an update on Byju's legal fights. As you are aware that Byju, who has been given a protection order by the Karnataka High Court against his removal from the company, the High Court has extended its interim order until March 28, staying the decision made in the Extraordinary General Body meeting on February 23, 2024. This meeting was held to expel the CEO Byju Ravindran. The High Court extended the stay order based on the representation made by Byju's lawyers and also to file objection raised by the investors. The investors contested the legality of the ex parte order, stating that the dispute is already under consideration of the National Company Law Tribunal and also that there is an arbitration clause. According to the company, the objection raised by the investors amounts to taking the Indian courts for granted, particularly by foreign investors. The court directed to file formal objections and fix the date for further hearing for March 28, 2024. You may recall that the company had questioned the shareholders' meeting, stating that the meeting was convened without following proper procedures in the Companies Act 2013. This wraps up this week's legal news roundup. But before I go, I have a little request from the entire LiveLaw team. We are an independent, fact-driven media organization that is committed to fearless and ethical journalism. To keep delivering your daily and weekly legal updates, especially in this dynamic audiovisual format, we need your support. So don't forget to like our video, share it with your friends, family, classmates and colleagues. Make sure you subscribe to our YouTube channel, drop your feedback in the comments below, tap that bell icon to get your notifications, and lastly, do visit our website www.livelawmedia.in for our in-depth coverage of Indian courts. I am your host Anna Oman and I hope you found this video informative and see you next week.